An Introduction to Clinical Documentation under the Law. Charting is not only a communication tool between interprofessional health team members, it is also an important legal document. Essentially, if you didn't chart it where the law is concerned, it never happened. According to the College of Dietitians of BC's Code of Ethics, dietitians must abide by federal and provincial laws that govern documentation and privacy, as well as policies determined within their health authorities. The major legislative act that regulate the legal requirements of clinical documents is the Freedom of Information and Protection of Privacy Act, or FIPPA. FIPPA's goal is to make public bodies more accountable and to protect personal privacy of patients. This means that a patient has a right of access to any of their personal records and charts, and they may request a copy of the record or ask to examine it. Policies regarding documentation differ between health authority policies. However, their goal is to follow the same legal standards as outlined by FIPPA. The following are some important considerations to keep in mind when charting. Keep in mind that patients are able to look at their records upon request. In addition, remember that medical records, including email correspondence, can be subpoenaed by the court of law. Therefore, it is very important to be mindful of the language you use when charting. Remember to keep a neutral tone and be as objective as possible. Since every health authority will have different policies around documentation, be sure to familiarize yourself with what policies are in effect at your particular health authority. This is especially important if you find yourself in a new health authority. Different units within a hospital may even have different protocols for documentation. For example, some abbreviations that are acceptable in one health authority may not be acceptable in another health authority. It is possible to modify a medical record if a mistake was made and a correction is necessary. Understand what the policies are for this according to your health authority. To conclude, health information is a sensitive form of personal information. Be mindful that it is our responsibility as healthcare providers to protect the privacy of our patients.